Truth to say that the legal position here is daunting in the extreme, because I have to say I'm a family law solicitor for about maybe 28 years, and when I get into the area of surrogacy, every time I ask a question, another question arises. It's like going down a road, meeting a cul-de-sac and coming back up the road and going down another road. So it is problematic, to put it mildly. But anyway, in this country, our laws are in our constitution and in statute law. And as it stands at the moment, there is absolutely no legislation in this jurisdiction in relation to surrogacy. And in effect, there is absolutely no mention of surrogacy in either our constitution or indeed in any of the statute books. It remains indisputable that the traditional heterosexual nuclear family is understood by most to be the central plank underpinning Irish society. And this statement rings particularly true in the context of Irish family law, where the entire legislative framework is premised on the rather antiquated principle that the marital family should be the primary, indeed sole beneficiary of all rights. Now, for the second time in a year, the High Court last week stressed that there is no such thing as a de facto family in Irish law. The issue of a de facto family previously arose in relation to a lesbian couple who had a baby with the sperm of a male friend. He later sought access to the child, and the couple opposed it, asserting their rights as a de facto family. And this argument was rejected by the Supreme Court in December '09, which ruled that such did not exist in Irish law and that the child had a right to know his biological father. Now, the current position in Irish law is that mothers have much stronger rights than fathers, both within the Constitution and the law. A mother is deemed automatically a guardian of her child in all cases. In Ireland, if the child is born to a married woman, her husband is presumed to be the father unless that is disputed. Where a woman gives birth to a child during an existing marriage to which she is a party, or within a period of 10 months after the termination by death or otherwise of a marriage to which she is a party, then the husband of that marriage is presumed to be the father of the child unless the contrary is proved. In Ireland, we have a concept called guardianship, which is not the same as custody. A person with guardianship is a person who has the authority and responsibility to make important decisions in relation to a child's general welfare. And these include decisions such as where will the child be schooled, the religious faith, whether the child will undergo surgery. Custody, on the other hand, is the day-to-day care of the child. And usually a guardian has the right to custody as against all non-guardians, although it is possible to be a guardian without custody if a marriage breaks up. A biological father is in a reasonably strong position. He can acquire guardianship by making a statute declaration along with the mother, or by going to court to get an order under the Guardianship of Infants Act appointing him a joint guardian with the mother. A non-biological father, as the law presently stands, has no right to seek guardianship or custody, although he might in certain cases be able to seek contact in respect of the child. In this jurisdiction, the adoption laws are covered by the Adoption Authority of Ireland, and the following people are eligible to adopt. A married couple living together. This is the only circumstance where the law permits the adoption of a child by more than one person. A sole applicant can also adopt, but only where the board is satisfied that in the particular circumstances of the case it is desirable to grant an order. It is not possible currently in this country for two unmarried persons to adopt jointly. When an adoption order is made final in Ireland, the adopters are treated in law as if the child were born to him, her or them in lawful wedlock. The responsibilities and rights of married parents are constitutionally legally very strong. This means the adopted parents are put in a very strong position. On the adoption of a child, the biological mother or guardian correspondingly loses his or her parental rights and duties. Thus, adoption necessarily involves the mother and guardian giving up their rights. Adoption law at the moment is in the process of being consolidated. There is a new adoption bill going through the Senate at the moment. And this is a very important point to be considered. Adoption will not be recognised in Ireland where the adopter parents or guardians of a child are paid or rewarded in respect of the adoption. This is currently the case, and it's also going to be reflected in the Adoption Bill of 2009. A person who is a prospective adopter, a parent or a guardian of a child shall not receive or agree to receive in consideration of the adoption of the child any payment or other reward. If the surrogate or donor mother is paid for her role and if adoption was envisaged as an outcome, then the adoption in this jurisdiction may not be recognised. Moreover, the adopters may be deemed to have committed an offence, the penalty for which is a maximum fine of €5,000 and or a term of imprisonment of up to 1 year. Similar provisions apply to those facilitating that adoption. Great caution is therefore required, as it is possible that a couple may be prosecuted on return to Ireland if money has changed hands in respect of the entire surrogacy transaction, if it includes adoption. Theoretically, it might be possible to separate the surrogacy arrangement from the adoption, where payment is made for surrogacy, but not the adoption. But an Irish court might treat the arrangement as a whole and regard the adoption as one for which consideration has been paid. There is therefore a very strong possibility not only that the resultant adoption would not be recognised, but that the adopters would be prosecuted on return to this country. Now, in relation to passports, it is very wise, if you're going to the United States to have a baby by surrogacy, to secure a US passport for that child. If the child is to come and live in Ireland, an Irish passport would also have to be obtained. I have actually requested some information from the Department of Foreign Affairs as to how they are viewing passport applications in relation to children born by way of surrogacy outside this country. If, for example, a Ukrainian woman acted as a surrogate to a married couple from Ireland, each of whom donated biological material to be used in the conception of the child born in the Ukraine, i.e. they were the biological parents, following is the position. As the husband is the natural father of the child, say in this case the husband is the sperm donor, the mother isn't, okay, it's an anonymous egg donor. In this case the husband is the natural father of the child, and because he is an Irish citizen, the child is eligible to claim Irish nationality and citizenship by descent based on the father's citizenship, pursuant to the Irish Nationality and Citizenship Act of 1956. But in the event of the Irish husband not being named on the birth certificate, as the father and the husband of the surrogate mother is named as the father, then an application would have to be made in this country for what is known as a declaration of parentage, and that would have to go through the courts here. Even if the Irish wife is an Irish national and or citizen, it does not automatically follow that she would have to be the mother of the child, even though genetically, say, the child is hers, as she was not the birth mother of the child, and therefore if the nationality and or citizenship of the mother was being relied upon by the child, a declaration again would have to be made for parentage. She wouldn't be eligible to get a passport by descent. The Department of Foreign Affairs has stated that neither this declaration of parentage nor a passport can be applied for prior to the child's birth. So if you are going by way of surrogacy in the Ukraine, you cannot get that passport prior to the child's birth in Ukraine. You would have to wait. So what they're saying is that the most appropriate application to be made once a child is born is for an emergency travel document pursuant to the Passports Act of 2008 to enable the child to travel to this state with a married couple. Any issues as to citizenship and the issue of a passport will be dealt with once the child is back in this country, and if necessary, appropriate applications will have to be made to the courts under the family law legislation. The general view emanating from the Department of Foreign Affairs is that the most appropriate course of action is to enable the child to travel and enter the state would be by virtue of this emergency travel document. Immigration acts currently do not address the issue of surrogacy at all. So the position at the moment in this jurisdiction, as you can see, is the lack of legislation is creating huge difficulties. There was a report in 2005 by the Commission on Assisted Human Reproduction. They made a lot of recommendations. It is gathering dust in some department's office, and that is the legal position at the moment in this country.